in the hands of the small businesses, so that now what this bill would do would require that if somebody does want to sue under the ADA, that they provide a heightened amount of information to the potential defendant so that they know what their rights are, what their possibilities are, and be able to push back a little bit. There are lots of stories about some attorneys, a few attorneys who are taking advantage of the ADA in order to essentially hold small businesses hostage. Those are the small businesses that need to get this information. And if we can make it that much more difficult, as this bill would do, to be successful in that arena, we should be able to cut down on the number of lawsuits that are less than meritorious and are meant more just to collect money from the defendants. And with that, I respectfully request an aye vote.
Thank you, Mr. Chairman. Witnesses in support? Seeing none. Witnesses in opposition? Seeing none. Questions or comments from the committee? Seeing none. Mr. Chairman, you may close.
Thank you. I request an aye vote.
Thank you. And as soon as we get a quorum here, we can proceed with a motion in a second.
Thank you, Mr. Chair. Item number 5, AB 1127. Mr. Cooley.
Mr. Chair, good morning. I'm here to present AB 1127. This bill relates to the development of family justice centers, which are one-stop centers where victims of domestic violence, kids in the families affected, foster kids, kids caught up in human trafficking can access services. They are very important in every community. Sacramento is a particularly sprawling community, so a one-stop place where people can go and get services under one roof and not have to drag everyone around is particularly important. So AB 1127 aims to support the development of family justice centers as this type of one-stop shop, and to support the establishment of such a center in Sacramento County. AB 1127 would allow the County Board of Supervisors to increase fees for certified copies of vital records like birth and marriage certificates to fund such a center. We know there's tremendous demand, unfortunately, for these services. 21,000 calls a year go into the hotlines that support these types of victims in our county, 21,000 a year. And so that's what this bill is designed to do, authorize the county to establish this type of charge. We know that children in homes of domestic violence are especially exposed to human trafficking and other problems. In Sacramento County, 76% of children screened by the juvenile court were found to be involved or vulnerable to recruitment to human trafficking. And these kids have a family history with Child Protective Services, and indeed 20% have an open CPS case. So there's a lot of social issues that come out of domestic violence settings. And we have Angela Pontes for Sacramento County, who's here in support. Angela, and I'll invite you gentlemen, but Angela, go ahead.
Thank you, Chair and members.
If you could hold off just a minute, please, and we'll establish a quorum.
Stone?
Here.
Wagner?
Here.
Alejo? Chow?
Here.
Chu? Gallagher? Here. Garcia? Holden? Mainshine?
Here.
O'Donnell?
Here. Thank you. We do have a quorum. Your first witness, please.
Thank you, Chair and members. Angela Pontes on behalf of Sacramento County. First, we'd like to thank the author for introducing this measure, and we're in strong support. The revenues generated by this measure would allow the county to better serve victims of domestic violence, family violence, and human trafficking through establishing a family justice center in the county. The Family Justice Center Collaborative in Sacramento will consist of government agencies and community organizations working together in one central location. Families can come and victims can go access all of their services in one place. This comprehensive approach to service delivery is vital to producing positive outcomes for the victims. For these reasons, we respectfully request your aye vote. Thank you.
Thank you. Next witness, please.
Mr. Hoffman.
Thank you, Mr. Chair. Sean Hoffman with the California District Attorneys Association, also in support. We've seen the success of the Family Justice Center model in a number of counties throughout the state over the last decade or so. As the author noted, it's a model where you bring together law enforcement, victim services, community-based organizations as kind of a one-stop shop to help victims primarily of domestic violence, human trafficking. So we ask for your support.
Thank you. Next witness, please.
Good morning, Mr. Chairman, members of the committee. Tom Sheehy with Greenberg Toreg on behalf of the California Police Chiefs Association. We're glad to be here this morning to support this measure. Thank you very much.
Thank you. Are there any other witnesses in support of this measure? Is there any opposition? All right. Seeing none, I'll bring it back to the committee. Questions, comments? Mr. Wagner.
Well, thank you, Mr. Chairman, and I'm very sympathetic with what you're trying to do here, but as we look at this, as I look at this, and my side of the aisle, I got a problem. Don't you need a 2/3 vote of the people to get this done? Aren't we running afoul here of Proposition 26? The fee, it's a new fee, and it's not directly related to the
For our
services.
purposes, the bill before us is not treated as a 2/3 vote bill. The county will decide. In our county, we've actually put many issues to the voters. The voters approve our Measure A. There's an awful lot of, I would say, in Sacramento County, they made this bill is permissive. It will allow the county to move forward with this. It gives them the authority. If it goes for the voters, I'm not too worried about that, Don. That's to implement this. The county will decide how to proceed. There are counties all over California that has these sort of centers. Some of them predate Proposition 26. They're configured different ways. This is permissive. It sets the boundaries on this program for Sacramento County, and the Board of Supervisors is supportive of this moving forward. Exactly how they will do it, it's up to them.
All right, but the bill does authorize them to do it without
Absolutely.
a vote.
This is a permissive statute specific to Sacramento County.
Okay. Without a vote. It does not require them if they exercise. No county need do this. Sacramento does not need to do this. If it chooses to do this, does the bill say you can do this only with a vote of the people?
Doesn't say that.
Thank you.
Mr. Gallagher.
Well, it's permissive right now, right? I mean, they could go out to their voters in Sacramento County and ask for a tax increase to support, this family law center, right?
Correct.
So why not just go ahead and do that, and instead, basically authorize the raising of taxes on vital records?
In this, Mr. Gallagher, in this, I am working with my former district attorney, Jan Scully, my current district attorney, my board of supervisors. They've requested this authorization. They're looking at these sorts of programs. They see the problem Sacramento County has with human trafficking. They're just getting their ducks in a row with this bill. I'm carrying my county's water, requested by my county supervisors, and my district attorney, past and present.
Any other questions? Mr. Chu. Thank you. We do have a motion. Is there a second? There is a motion, a second. Further questions? All right. Seeing none, Mr. Cooley, you may close.
Request your aye vote. Thank you very much.
Thank you. The motion is due pass. If you could call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
No.
Wagner, no. Alejo? Chow? Chow, aye. Chu? Chu, aye. Gallagher? No. Gallagher, no. Garcia? Aye. Garcia, aye. Holden? Mainshine? No. Mainshine, no. O'Donnell? Aye. O'Donnell, aye.
Needs one more, so we'll put that.
Very
bill
good.
on
Thank
call.
you very much. Thank you, colleagues.
Thank you. And I'd like to take a motion on the consent agenda, unless someone would like to remove an item. There's a motion and a second on the consent agenda. If you could call the roll.
Stone?
Aye.
Stone, aye. Wagner? Aye. Wagner, aye. Alejo? Chow? Chow, aye. Chu? Chu, aye. Gallagher? Gallagher, aye. Garcia? Garcia, aye. Holden? Mainshine? Mainshine, aye. O'Donnell? O'Donnell, aye.
Thank you. That is out. That is AB 897 and AB 1085 on the consent agenda are both out. We heard earlier item number 7, AB 1521. The recommended motion is due pass. I'd like to take a motion on that. There's a motion and a second. You call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Aye. Wagner, aye. Alejo? Chow? Aye. Chow, aye. Chu? Chu, aye. Gallagher? Garcia? Aye. Garcia, aye. Holden? Mainshine? Aye. Mainshine, aye. O'Donnell? Aye. O'Donnell, aye. Alejo, aye. Alejo, aye.
Great. That bill is out. Thank you. That now takes us to item number 1, AB 359. Ms. Gonzalez.
Good morning. I want to start off by saying that I accept the proposed amendments in the analysis. AB 359 seeks to protect up to 383,900 grocery workers in California from losing their jobs during large grocery mergers. The cities of San Francisco, Los Angeles, Gardenia, Alameda, and Santa Monica have already taken the step forward to adopt local ordinance aimed at protecting grocery workers in their locale. Furthermore, in 2011, litigation between the California Grocers Association and the City of Los Angeles was resolved when the California Supreme Court ruled in favor of the ordinance that was passed there in 2005. This bill mirrors that ordinance. Problems occur in California when large grocery acquisitions take place in our communities. At the end of the day, a high number of jobs are put at risk, wages are reduced, and workers are fired. It's an unstable situation for many of our communities. Historically, these are good-paying middle-class jobs and have played an important role, have been the backbone, in fact, of communities like mine that have very few middle-class jobs. Under AB 359, grocery stores that are larger than 15,000 square feet will have to ensure the retention of eligible workers during 90-day transition period when they change the ownership. Eligible workers will be considered for continued employment after the 90-day transition employment period by the successor employer, but there is no obligation that they will be hired. I think it's time to protect our workers and jobs in our state when Wall Street takeovers happen in the grocery industry. Members, I respectfully ask for your aye vote.
Thank you. Your first witness, please.
Mr. Chairman, honorable members of the committee, Sam Rodriguez, on behalf of United Food and Commercial Workers, we represent about 160,000 grocery workers in the state. And overall, there is close to 400,000 grocery workers in the state of California. 2 years ago, we commissioned a study at the University of California, Berkeley Labor Center, where we did extensive comprehensive study of the industry. And we found that the industry has actually grown and grows even further when during a recession period. We also analyzed every retention bill in the state of California, Los Angeles, Santa Monica, and San Francisco. Not one retention bill impeded any growth in the grocery industry. Matter of fact, San Francisco, which is about a million folks, since 2006 of their retention bill, there has been over 5,000 jobs created, and 5 grocery chains have been located in San Francisco, 2 Whole Foods and 3 Trader Joe's. So the industry itself is growing quite well. What we did see in the study, we saw wage stagnation. We saw severe wage stagnation for the last 10 years. So we have this dilemma that we're asking for you to advance this bill and onto the floor because we are in a place where we may lose really good middle class jobs. In the state of California, of over 3,200 grocery stores in the state, operated by the top 20 companies, grocery store companies, 41% are now owned by private equity firms. As all you know, private equity firms do not file financial statements with the federal government or with the state. So there's a lot of anxiety and a lot of uncertainty of the future. We respectfully ask for your aye vote. Thank you.
Thank you. Next witness, please.
Thank you, Mr. Chairman, esteemed members of the committee.
Could you push the button at your microphone? Thank you.
My name is Justin Rauza, the Policy Director for Roots of Change. We're a food systems nonprofit that have been working on food policy in the state for the last 12 years. The reason why we're co-sponsoring this bill and appreciate Assembly Member Gonzalez's leadership is talking about the issue of the 90-day retention, which is a temporary window but it's enough time that would prevent some really devastating impacts on the state. Here in California, 1 in 6 Californians are food insecure, which, as defined by the California Health Interview Survey, is the inability to consistently afford enough food. If you look at Californians who are at 200% or below the federal poverty level, which is the gross income cutoff for CalFresh, that rate jumps up to 42%. Without a 90-day retention period, people can go from having a good-paying job to having no job at all. And guess who ends up supporting these folks, these community members who are also grocery workers? Well, it's the state of California through CalFresh, through CalWorks. And there was a recent report that was issued at the end of last week by the Labor Center, again at UC Berkeley, which showed that California and Texas are the top 2 states in the nation that end up supporting corporations basically through the public safety net. And so when we look at the food system, look at these workers also as community members and wage earners, we respectfully urge your support and your aye vote for AB 359. Thank you.
Thank you. Next witness, please.
Thank you, Mr. Chair. Members, Mitch Seaman with the California Labor Federation, also here in strong support of the bill. We would just echo the comments of both the author and sponsors and would also point out that we think this bill makes a lot of sense for a variety of reasons from both the perspective of the employer and the surrounding community as well as the workers. For the employer and surrounding community and potential customers, we think that what this bill does is make sure that for a lot of these workers who've devoted, in many cases, years, if not decades, of service to this industry, that they've developed a wide variety of experience in how it works, how to keep our food supply safe, and how to provide customers with the service that they need. And what this bill does is essentially give them just sort of a 90-day period where they can stay on the job, they can kind of audition, that their experience can be used and employed in a way that makes sure that all of those years of service that they've dedicated to the industry can be used in a way that benefits both the community and the employer. And then for the workers, if for some reason, if there is a reason for an employer to get rid of, the opponents pointed out that there's a concern that if there was some problem with an employee, they wouldn't be able to get rid of them. The bill clearly allows those workers to be let go for cause if there is a reason. But if there isn't a reason, then the worker still gets to keep their jobs, still gets an opportunity to show that they do have a lot of experience that could value both the community and the employer. And for those reasons, we'd urge an aye vote.
Thank you. Is there anyone else in support? If you could state your name, affiliation, and that you support the bill. Any other witnesses in support? Seeing none, is there any opposition? Come forward. Just make room for them at the table, please.
Thank you, Mr. Chairman and members. Carrie Askew Bailey with the California Grocers Association. We are here in opposition to the bill today. Just to be clear, this bill does not cover all grocers in California, and it does not cover all what is being classified as Wall Street corporations. To be covered by the bill, a company has to be operating a store that is 15,000 square feet or larger, and the language of the bill is primarily be selling foodstuffs. We have significant concerns that major players in California's grocery industry are not covered by this bill, while others are inexplicably singled out for disparate treatment, essentially. We also have significant concerns because what the bill does is set up a system where some companies, in some cases, opening new stores, and that being when they purchase a store that is operating as a grocery store already, would have to essentially set up two different sets of treatment for their employees. Folks that they hired of their own accord would be covered by California's at-will employment presumption. They also would be covered by the same, rules, if you will, that apply to employees at other stores that the company operates, whereas you would have one set of employees retained under this statute that would be only allowed to be terminated for cause. They would get a written performance evaluation at 90 days, which may not be the practice for other employees in that company. And according to the analysis, it actually even leaves open the possibility that they would be covered by different employment terms generally if a collective bargaining agreement was in place. We are aware absolutely of instances with our member companies where companies have made decisions to not expand further in the city of Los Angeles. One company, for example, we are aware plans 25 store openings in California. They are not considering the city of Los Angeles because they are concerned about this issue. We are aware of sales transactions that did fall through in July of 2011 when the courts finished their process and the ordinance was put into effect. So we would argue that this actually creates barriers to store development and will have a net effect of impacting the ability of grocers to serve California consumers.
Thank you. Next witness, please.
Good morning, Mr. Chair and committee members. Jennifer Burr on behalf of the California Chamber of Commerce, and we are opposed to this bill. I just wanted to follow up on some of the concerns that Ms. Bailey identified. First, with regards to the analysis that suggests that these employees would be subject to instant termination if this bill doesn't go into effect. I disagree with that, given California's WARN Act that specifies that if a business is going to shut down or lay off employees, they have to actually provide 60 days of notice to their employees before that termination, layoff, or shutdown actually occurs. So we already have protections in place. There's a federal WARN Act as well that requires a same notification to employees. We disagree with the characterization of this as only a retention period. From our perspective, given the fact that you can only terminate these employees for just cause, essentially, after 90 days, and you can only look at their performance during that 90-day period, you are limiting an employer's ability to actually determine who they want to hire after that 90-day retention period. And from our perspective, that this is basically an opportunity for the labor unions to avoid an election process. Our concern is that if you try to eliminate or terminate an employee for just cause at the end of that 90-day retention period, you're going to be facing an unfair labor practice charge. With regards to the union issue, under the National Labor Relations Act, it specifies that if a successor employer comes in and voluntarily chooses to take over a prior employer's employees, they have to recognize the existing bargaining representative and continue to negotiate with them. This bill mandates, essentially, from our concern, that you can't really terminate any employee after the 90-day period to hire the prior employer's employees, and therefore it triggers the successor employer doctrine and requires the successor employer to begin to immediately recognize the existing bargaining representative. So we don't mind, obviously, if there's a labor representative in the workplace to go through the National Labor Relations Act and the election procedure, but to sidestep that election solely by mandating that you retain the employees is a huge concern from us. And then for the last point, from our perspective, this isn't a job saver. It's not a job creator. It's only a limited for those employees of the prior employers. If the successor employer comes in, they're going to hire employees. They're going to either bring their existing employees or they're going to hire employees in the community, including those that may be on CalFresh or CalWorks or having a hard time. Those employees are going to have or those members of the community will have an opportunity to get a job. This just provides stability for a very limited group of employees of the prior employer at the jeopardy or loss of other employee or individuals in the community who could have those jobs. For those reasons, we're opposed.
Thank you. Next witness, please.
Margaret Gladstein on behalf of the California Retailers Association. I concur with the previous witness's testimony. I'd also like to add that if you look at the intent language in this bill and you were to substitute legislative workers and legislators for grocery workers and grocery stores, you'd come up with very similar intent. You could argue that the state has a compelling interest in ensuring the welfare of its residents and its communities through the maintenance of health and safety standards in the legislature, and that experienced legislative workers with an experience-based understanding of the clientele communities in which the legislator is located are essential in furthering the state's investment in health and safety. But we didn't mandate that any of you retain your predecessors' employees, and that's exactly what we're doing here with this legislation. All of these reasons that you could argue apply to grocery workers would apply to you as well. There are many reasons that people don't want to retain employees. Sometimes the style of the store changes. You can see shifting neighborhoods, so you can have an ethnic grocer come in to a neighborhood as the neighborhood is changing. The neighborhood can be gentrifying. So there are lots of reasons why the old employees may not fit. Many times when they do fit, grocery stores actually retain those workers, and it's the benefit of all, but other times there are stylistic changes that make sense for workers to change. And we think that each grocery store should be enabled to make their own choice as they take over new sites. Thank you.
Thank you. Any other witnesses in opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Ms. Garcia.
Good morning. I want to thank the author for spending a large chunk of her morning with me discussing this bill today, so I do appreciate that discussion. I want, like you, to protect workers, and I think that in terms of making sure that they have that buffer stage of whether it's 90 days or 60 days or whatever, I think that premise I'm very much in support of. As I looked at the bill, as I heard the testimony, and we talk about our own employees and how well that they are, there is that question of, are we taking care of all employees or just some? And in our discussion, I agree that sometimes we have to take incremental steps forward. That's a lot of that I do here. So while I do think there's something to be said about looking at these other employees that might not be protected, there's something to be said about that incremental push. And so in that sense, I think we found some common ground this morning when we were discussing. One of my concerns was the number of lawsuits potentially that could happen here. And we discussed the private right of action. And I wanted to see if you were open to taking an amendment before this comes to the floor that removes the private right of action language in this bill.
Yeah, and as we talked about this morning, I am willing to remove the private right of action before taking it up on the floor, if it passes this committee.
Okay, and thank you. That I do appreciate that there. So, and just to be clear, because I don't know today, but can you address the part of the opposition about the Warren Act and the 60 days and whether or not that creates a cushion for these employees?
I actually didn't hear that in the previous committee, and so I wasn't prepared for that argument, quite frankly. But we know from past experience what has happened, unfortunately, when even some of our responsible employers have shut down. And there have been situations in the past, especially when in the early 90s, late 80s, when the Wall Street mergers and leverage buyouts and hedge fund takeovers of the grocery industry started, and there were massive layoffs announced immediately. I don't know if that was corrected somehow, so I actually just would have to, I was trying to look it up actually on my phone as she was speaking, but we know that it has happened in the past. We know that it happened as quickly as 2014, 6,000, January of 2014, 6,000 Chicago workers, grocery workers, lost their jobs immediately in Chicago under this type of pressure from a hedge fund operator that operated with a otherwise responsible grocery chain, which is to go unnamed, that these experiences has happened. The 90 days allows two things. One, the worker to prepare if they're not going to have a job anymore. But two, it also allows the worker to be able to make their case to the employer. And I think a lot of times that given that opportunity, there's a lot of fear, I think, when employers come in, especially if there's a unionized workforce. I'll be very honest. I'm not going to side skirt this issue, that somehow a company who has never dealt with a unionized workforce may not understand or may have preconceived notions about the workers in that environment. This allows them to make their case, and I think that's a positive thing.
Okay, and then just my last question on, so the incumbent grocery store owner would provide a list of all eligible employees. The successor employer would then hire all those individuals for 90 days, or just hire from within that list, but it doesn't guarantee that all of those individuals in that list get hired for the 90-day window.
The success for the 90 days, the successor employer needs to retain the workforce, and if they are in fact diminishing the workforce, like if they're going from 150 workers to 140 workers in that location, it has to be done by seniority, or if a collective bargaining agreement exists, by the terms of that collective bargaining agreement.
But that could be done before the 90 days, or that's done after the 90 days?
No, that's done for the 90-day period. As soon as the 90-day period is complete, then there is a evaluation, written evaluation, so that the employer is actually doing their job, evaluating these employees, and then post 90 days, they have to interview, but do not have to offer any of those workers a job.
So
interview probably they have to consider through an application process.
Maybe my question wasn't clear, but so technically, on week one that the successor owner takes over, if they decide in that week one or right before that they only need 140 and not 150, they could let go of the 10 employees who are at the bottom of the seniority list.
Yes.
Okay, thank you.
Mr. Gallagher.
So, I have a few questions here. California status quo is we're an at-will employment state.
Mm-hmm.
So when we move away from, that at-will status quo, there's got to be kind of a big reason for doing so. We don't do this in any other industry. How big of a problem this is? How big of a problem is this? I heard in the testimony that there's problems with wage stagnation. There was a study done along those lines. But what I didn't hear is how often this happens where a new grocery store ownership comes in, and does everybody get fired?
Mm-hmm.
I'm sure they retain a lot of the employees. Maybe they don't retain all of them. But, where's the data that this is such a big problem that so many people are getting fired?
Okay, so you brought up a couple issues that I want to address. First, that the fact that we don't do this in any other industry is not true. We actually have a janitorial worker retention law in California. We also have, in different locations, for example, at a lot of our airports, we have a worker retention policy so that when you change a contractor, smaller stores, but stores nonetheless, that you retain the workforce there, right? So we do have worker retention ordinances that provide for this, right? The at-will portion is only being done away with for 90 days. After that 90 days, that workforce goes back to an at-will situation. So it's not as if we're undoing, as much as I would like to undo California as an at-will state. That is not what we're doing here. We're providing a 90-day cushion, right? To the last question. In my previous experience as a labor leader, I will say this. It is very common in a transfer of a business, especially if it was a unionized workforce, to get rid of the entire workforce. Because if you retain over 50% of the workforce, then you have to actually bargain with the union. So even in an at-will state, when you are not supposed to make decisions based on union membership, even in cases that we had in San Diego, not in a grocery store, but in a restaurant, where the new owner says in the newspaper, no, I'm getting rid of all of these employees because they're union and I don't want to have to bargain with the union, and where there is an unfair labor practice, this happens. So, and I understand that some employers have utilized the NLRB process and our weak labor laws to get rid of unions, and that's why union density continues to drop. So, yes, it does happen. We just saw it happen last year in Chicago. Whole Foods, took over of the stores that took over union stores in Chicago. 11 of them were bought by Mariano's, non-union, 4 by Whole Foods, non-union, and 4 by Jewel Osco. They actually were the only workers who kept their job because they had a union contract. And so 450 workers of the 6,000 got to keep their job. We probably have an ideological difference about the role of unions in a workplace, but it is often done.
Well, that's not what I'm really concerned about here. I'm more concerned about how often is this actually happening? How much is this a problem in this state? And I just haven't heard any real objective data that suggests that this is happening throughout California. Your example is from Chicago.
Well, that was the last massive sale. Like, what we're talking about is big grocery store chains. In California, of course, we just had a very good experience, thank God, in San Diego, where a unionized grocery store took over a unionized grocery store, and we got to retain all of our workers so that there was no disruption in the community or massive layoffs. In the past, when we've kind of seen this unsettling of the grocery market, which the last time we saw what's happening now was in the late 80s, in early 90s, it happened a lot. So we're prospectively looking at the market and what's going on. We kind of have this situation where large shareholders are pressuring the breakup of big grocery chains, and so we're trying to prevent what happened during that time.
Okay, well, that goes into my next question for you, which is, is this kind of being presented as, hey, we're getting at these Wall Street shareholders, big, they're just interested in profits. They're coming in. The data I heard was 41%
private
equity owned. So that's 59% that aren't, right? So the small mom and pops, the family-owned businesses that are in the grocery business, they're going to have to deal with these same requirements, right? When they purchase, their competitor's grocery store, or when they move into a new neighborhood, they purchase that grocery store. they're now required to keep all those workers. And arguably, maybe that grocery store didn't work out because of the game plan that they had. They're coming in with a new strategy, a new way of going about it, and that might require changing the employees of the company. Well, so why would we want to penalize them? They're not Wall Street. I'm talking about small mom and pops.
I'd love to see a few small mom and pops with a 15,000 square foot grocery store. I don't know how many. I could look that up and give you the numbers. But 15,000 square feet is a large market. This isn't, I have a number of neighborhood markets in my district, thank God, because some of the large markets won't locate there. And this does not affect their abilities to buy and sell. But when those small mom and pops become big conglomerates, and that has happened, especially in ethnic food markets, then they're subject to another set of rules, yes. But I'm not worried about those who started off maybe as a small mom and pop and have worked their way up and now own a number of very large chains.
So if we're really focused on these large conglomerates, right, then why the language about how to be primarily engaged in the grocery business? Because we know we have superstores in this state that maybe are not primarily engaged in grocery, but they're doing grocery business as well. Are they covered by this bill? And if not, why not?
They're not, because we're dealing with grocery workers. Unfortunately, the superstores just haven't created good middle-class jobs that we worry about retaining. I haven't seen the buying and selling of large superstores they're not subject to the same kind of whims of the market that we're seeing right now in a smaller grocery store. In fact, a lot of what we're seeing in the grocery store is because of the bad practices of those large super centers. And so, quite frankly, I couldn't even imagine a stated need in that for a variety of reasons. Like I said, one, they're not providing good middle-class jobs. They never have, and that's been part of the problem. And two, they're not buying and selling. In other words, if Walmart went out of business, and a new company came in, I'm sure that new company would offer those workers minimum wage jobs, just like Walmart.
Yeah, but I mean, aren't we creating sort of an unequal playing field when we, are going after this sector of the industry? And that sector of the industry does include family-owned businesses. They may be large, but they're still family-owned. They're not private equity firms that own these companies. So we're saying, hey, you're going to abide by one set of rules, but the large conglomerates that you're talking about don't have to abide by those same rules.
So I'm not picking on anyone. I actually, the people that this is targeted towards have been, for the most part, responsible employers for a very long time in our state, right? But they're under pressure. They're the ones that are under pressure from hedge funds and from Wall Street to break up and sell a lot of their assets. We want to make sure that those workers who have devoted 10 or 15, 20 years to a company have the ability for 90 days to prove themselves to a new employer. It's not picking on an industry, it's protecting a class of workers.